Okay, now, I was asked to deal with the speed of delivery. Was it too fast? Too fast by who decides how fast and whether it is too fast? The prosecutor said this. He said, anyone listening to the recording would conclude that the judge did not speak too quickly. Rather, he maintained that the trial judge spoke articulately and clearly, and what he said was easy to comprehend. This is the prosecutor basically saying there should be no appeal and this judgment should stand. The judge did not speak too quickly. Well, I was asked to do a linguistic analysis to find out what speed did the judge speak. All of it revolved around the end of the court case where the judge gives his summing up, his summation, the last 2 days of the court case. The first day was 70 minutes, a little over an hour. And then on the second day, it was nearly 2 hours. And this is the judge just reading. And this is the interpreter is supposed to keep up. And the jury is also supposed to be paying attention for those few hours. So how can we assess the speed with which the judge was speaking? There is basically a kind of structure that the text has. He gives his opening remarks. He directs on some important principles of law. He gives directions of law. He talks about the elements of the offense. And then he gives a summary of the evidence. This is day 1. 70 minutes. In fact, he was supposed to end sooner. There's a usual time that the court case is supposed to end. And he then asked if the jury would allow him to continue for another additional 15 minutes. So the whole thing went for 70 minutes and 24 seconds, okay? Now, this is for each of these sections, the words per minute. So what I needed to do was to look at the start and the end of each of these sections, look at how many minutes took place, how many words were spoken, and then average that out to find out how many times the words per minute. And so you can see the totals. We have 137, 144, 150, 145, but then he gets faster. And that's when he gets 161 and 176. So he's speeding up. Why? Because he's getting near to the end for the day and he's trying to finish in time. Okay, so he speeds up. Average, not bad, 155 words per minute. This is day 1. Day 2, nearly 2 hours. It's broken up. There is a break for about 20 minutes. And you can see the words per minute, 162, 174, 185, 197. Very nearly 200 words per minute. Well, what's the average? What's expected in terms of speed with which we usually would be talking? This just gives you an overview of the day 1. He's speeding up, 176. And in day 2, again, he maintains, he speeds up until just the very end. Question: how does the judge's speed of delivery compare with the normal speaking rate for this situation? What would be normal? Okay, let's try to find some bar by which we can assess this. And so what I did was I looked at, in this case, it was the 11th Judicial Circuit Court organization, and this was a statistic. It's supposed to be what a court reporter should expect. What is a court reporter? Where they are actually keeping track of everything that is said, okay? The 11th Judicial Circuit Court in Illinois, USA, estimates the average rate of speech during court proceedings to be 150 to 160 words per minute. All right, so on that first day, that was pretty much the speed, okay? It was 155, if you remember. There is a certificate test in California for a court interpreter. And what they're given is a 3-minute tape recording, and the speed is 140 words per minute. Okay, so we have two sort of numbers here. 140 would be the certificate test for 3 minutes, by the way. This is going on for 2 hours, comparatively, right? And at a speed of, well, it began 150, 160, but became much faster. Keep in mind, though, you have to realize that there are different kinds of exchanges that take place in the courtroom. It's not just this summation of the evidence. There's other things that take place. Now, sometimes it's extemporaneous. No, when for example, the counsel is asking a question of the defendant or a witness, that is extemporaneous, and the person replies. It's not scripted. But the summation of evidence is scripted. It is written out by the judge. So you have to consider, first of all, how was the speed? How long was the discourse? How long was the text? How long did it go on for? And what was the nature of it? Was it spoken? Was it written? It was spoken by the judge, but it was scripted, so he was speaking what had been written. Differences in mode of delivery, whether spoken or written, scripted or free, have consequences for the form that language takes. Now we know that. And what is that? The mode of delivery is going to impact. You can't just make a general judgment. How fast was he? It depends on what was being said. And when you read something aloud, you are much faster than when you are talking extemporaneously. Speakers reading from a prepared text tend to deliver faster. We don't have the pauses. We don't change the pace or repetitions, which normally help to convey meaning and which give spoken language its immediate intelligibility. So that it's not only what is being talked about, it is who is talking here. It is the court judge talking to who? Who is he giving this summation of evidence for? Jury. Now, arguably, and this was an argument later, the prosecutor says, why does it matter if the interpreter didn't interpret the summation of evidence well? It wasn't for the jury, it was for the defendant. Now we'll come back to that question. The other thing that took place was day 2, summation of evidence, in the morning. The defendant's counsel, Mr. McCoy was his name, he said to the judge, "We believe you are speaking too fast. We believe the interpreter cannot keep up with what you are saying." So the judge, they had told the judge already that there is a problem. But what happened on day 2? Day 2, he got even faster. In the morning, he's told you are talking too fast, and it isn't the interpreter cannot keep up with you. And what does he do? Does he slow down? No, he speeds up. Why? Because he's under great pressure. The jury is already ready to walk out if it drags on much longer. He has to finish the trial as quickly as possible. That is also one factor. It shouldn't be, but it was. The judge's summary of evidence given by the defense's expert witness. This is critical. I looked at 6 minutes and 26 seconds in particular, because this was where the summation of evidence was being given, and what was being summed up was the defense's expert witness. The defense's expert witness about the DNA that was on the drugs and so forth. The defense's expert witness, which would be important for the defense. The judge spoke the fastest, 200 words per minute. Remember, during the judge's summing up, the judge is reading. He's reading from a prepared written text. So you might say, well, but the speed, was it really too much to keep up with? Well, the court interpreter, because the court interpreter here is actually doing what translators do like at the United Nations, because at the United Nations, they're translating written text from speeches, right? United Nations, the basis of this, the United Nations stipulates a requirement for translators that they do 6 to 8 pages, or 2,000 to 3,000 words per day. That means if you translate that into what was being expected of the interpreter in this courtroom, was that he should be doing interpretation at 40 times the speed of what a normal translator would be expected to do. Not speaking to this instance, but in other instances, one of the comments that's been made is this absurd pace quickly reduces the interpreter to a state of mental and physical exhaustion, and his usefulness to the listener is practically nil when compared to the service he is able to render when dealing with free speech. My point is this, that even if it is a professional interpreter, the speed is such that it would make them exhausted, because it goes on for a much longer duration than what we might have expected. But you know, the other thing that was important to look at was it isn't just about the speed. What else should we be looking for? What else can we say about language? I want you to be thinking about this from the standpoint of a text. The lawyer, the attorney for the defense, when they asked me to review the language that was used, all they thought about was the speed. How fast was it? But we know there's more to it than that. There is grammatical complexity. There's a very famous study that was done of jury instructions given by the judge, very similar to what we are talking about, because we're talking about summing up the evidence for the jury. And this study, Charo and Charo, 1979, it's an old study, but it's sort of the classic, and it identified 3 considerations. 1, the use of passive constructions in supportive clauses. Dependent clauses. Is the passive being used? 2nd, the combination of many clauses within one sentence. 3, with deletion. What's with deletion? With deletion is where the relative pronoun and the verb is are eliminated. Okay, let's look at some of these. And these come exactly from the summation of evidence. In the case of the DNA material found on the wrapping of lump PI exhibit P1, okay, so this is a passive construction and it is within an embedded clause. There are at least three possible points. Again, another passive construction within an embedded clause. Well, that's one of the features. We can find examples of sentences that go on with many clauses. The third possible point of transference would have taken place inside room 1740. Next clause, according to Dr. Lane. Next clause, after the video recorded interview of the defendant had concluded. Next clause, and Officer Mac 8195 entered the room. Next clause, to perform the task of putting the exhibits, especially the drug exhibits, into the tamper-proof envelopes. All right, so first of all, we see passives in embedded clauses. We see long, lengthy sentences. And we see a number of these. With deletion. Removing the relative pronoun and the verb to be. Explain to us the research conducted on the transference by way of an investigator's log onto another surface. All right, so let's take a look here. In this particular sentence, we can see all three. We have the use of passive constructions and subordinate clauses. We have a combination of many clauses within one sentence. And we have with deletion, omitting the relative pronoun. The evidence in our case would consist of the oral testimony of the witnesses, both for the prosecution and the defense, who were called to the witness box, the three sets of admitted facts, and all the witness statements that were read to you both by the prosecution and the defense, and all the evidence which was admitted reduced into one. Think of that being spoken at 200 words per minute. And who can keep up? This is why I say, yes, this is the register. Yes, this is the expectation. Yes, this is what judges do. They sum up the evidence. But does it fit the needs of the context? Does it fit the needs of those who are hearing it? We're not done yet. We also have the lexical density. What is lexical density? Typically, when I'm talking, and I'm just talking to you, there would be typically within a clause 2 content words. Not grammatical words, not prepositions or things like that, okay? But content words. Extemporaneous speech typically contains 2 lexical words. Written language, when I'm writing, what is written to be spoken is likely to contain 4 to 6 content or lexical words per clause. In scientific writing, lexical density can increase considerably, up to perhaps even 13 words per clause, content words. Not how many words in the clause, just lexical words, just content words. Here's an example from the judge's summation. There are 15 content words. In other words, the lexical density, the density of information that is being conveyed is high. The speed is fast. The clauses are complex. Now that is quite an insurmountable challenge. And I would say, not just for the interpreter. Yes, the interpreter in this case was not trained, was not a professional, but even if a professional. So I did an analysis. What I'm looking at is the content words per clause. Rank shifted nominalization is the subject. What I understand Dr. Lane to be saying in the evidence, is the subject is a lengthy nominalization. Passive voice in a subordinate clause, with deletion, and the number of non-rank shifted clauses. So I do the analysis throughout the text. And I was specifically interested in that 6 minutes. The 6 minutes where the judge is summing up what is critical to the defense. "200 words per minute." And notice the lexical density, which is higher than 10. We see the number of clauses, the number of embedded passives, the amount of with deletion. And what we're seeing is a very complicated text. Oh, on top of that, there's a certain amount of ambiguity that is also there. Here is a statement that the judge made. Mr. X mentioned to Officer W. Now, in the actual text itself, it gives the names, but I deleted the names. That the defendant seemed to have coughed and cleared his throat, exhaled strongly, tapped the table, tapped the telephone, stretched and leaned forward, rubbed, wiped his eyes, lips and nose a few times, rubbed or scratched his face, head and neck a few times. These. Well, what's these? I assume everything here are all things that members of the jury, you can see for yourself. Now, when he says it like that, he's basically saying, you have no other, you have to see it that way. You can see it for yourself. Of course, he goes on to say, for you to decide if they happened or did not happen. But he's basically saying, here are all these things you can see for yourself. Here, it was specifically pointed out to Officer W that at counter 992 or such time of the video recorded interview, the defendant had reached out to touch one of the plastic bags containing one of the lumps of dangerous drugs. Officer W agreed, but stressed that the defendant did not directly touch the lump, just the surface of the transparent plastic bag. What is it that is this? What is this? Again, this is recorded on a disc. What is this? Is it this? The defendant had reached out to touch one of the plastic bags containing one of the lumps of dangerous drugs? Or is it this? The defendant did not directly touch the lump, just the surface of the transparent plastic, which we don't know because it's ambiguous. What is the field, tenor, and mode here? The judge is delivering the summation of evidence. There is a use of specialized legal terminology. This is legal technical jargon. That's the what? That's the field. The judge is reading summation to the jury. The interpreter is translating for the defendant. That's who's here. That's who's part of this. Mode. It is a written statement read aloud by the judge to the jury for just over 1 hour on day 1 and over 2 hours on the second day. Summation read aloud for over an hour on the first day, interrupted by a brief break of 42 seconds, during which he requested an additional 15 minutes, and nearly 2 hours on the second day, interrupted by a break of 20 minutes. The court interpreter was required to mentally process and interpret the judge's summing up into Tongan, which has the rarest major type of word order, verb initial. And the court interpreter needed to carry out his task at 40 times the speed of that required by United Nations translators of similarly written documents. My observations. Judge Y read his summation. So as with other written texts, his summary carried a high information load, high lexical density, compounded not only by a substantial amount of technical jargon, but also complex grammatical constructions, requiring considerable mental alertness and language proficiency in order to be processed, comprehended. The judge's summing up, delivered at a rather fast pace for over an hour, must have taxed the mental processing of the court interpreter to such an extent that his performance would have been significantly diminished. What are the demands of the context? The receivers, the jury, the translator. One thing that surprises me a great deal is there's just no fault for the jury. And yet this is supposed to be for them to decide. The receivers, the jury and the translator, are required to be familiar with specialized legal terms. But these are just normal people. Okay, the interpreter didn't know. And in fact, the interpreter can interrupt the court and say that he doesn't follow and that he needs to be able to have something clarified. Now, this football player brought into the interpretation, he did not know that. Has he never done this? This isn't his usual job. The summary carried a high information load, substantial amount of technical jargon, complex grammatical instructions requiring considerable mental alertness, language proficiency in order to be processed, comprehended. Question remains whether the defendant can be considered to have had a fair trial if it's only the summing up that is in question. Now, here is the question that was raised. If at the summing up, and I mentioned this a moment ago, it's for the jury. It's not for the defendant, but yes, in a way it is for the defendant, but it's really for the jury to decide. The prosecutor, he argued that the judge's summing up is addressed to the jury, not the defendant. So whatever deficiency existed in the interpretation of the summing up for the defendant should not call into question the verdict delivered by the jury. And then he cited a case where, in fact, the summing up had not even been interpreted at all. The judges, hearing the appeal, replied that this particular case the prosecutor had mentioned should not be in any way considered to devalue the importance of summing up or suggesting that the defendant did not have a right to have the summing up interpreted for him. Moreover, what they pointed out was in that particular case, the prosecutor had mentioned, the judge had given his summation in advance to the defense. Everyone in the court had his written summation. They could read it for themselves. I think I told you last time, when I came there and I was brought in and I was supposed to be ready to give testimony, I'd written the report. The report had been read by the appeal court justices. So I'm sitting there, and after the judges came in, one of the first things they said, and I told you this last time, we do not want to hear Professor Webster. Why? Because they do not want to hear that this is in fact very problematic. Not only is it an issue of speed, it's an issue of grammatical complexity, lexical density, ambiguity, all these features which are related to the way in which this text, a written, scripted speech, is expected to be heard for over an hour, one day, 2 hours the next day, at a speed that is beyond what we would normally expect. They don't want to hear that because that is the way they do it. And they don't want to change it. So they don't want to hear that it doesn't fit context. It doesn't meet the demands of context. The linguistic evidence conclusively explains not only the interpreter's inability to provide adequate interpretation assistance, but this was my point. And this is what they did not want to hear. The excessive linguistic demands placed on the interpreter are not just on the interpreter, but on the jury as well. And there is no way anyone could have followed that summation of evidence. So what did the jury probably do? Probably basically slept through it. Okay, so why is the summation of evidence important? Why is it important? What does it do? What is its function? What is its purpose? What I hope you're seeing is that in addressing this question, when I was asked to address this question, the question to me was, how fast did the judge speak? That's really just all they wanted to know. But as a linguist, what are we doing? We're looking at a text. We're asking ourselves, we're noting that it doesn't just matter of how fast. There's other factors as well. So, but why is it important? It is supposed to be a neutral summing up based strictly on the facts of the case. Or is it the judge's version of the facts? When he increased his speed when describing the evidence given by the defense's expert witness, this was truly a fault. He did express a certain bias against the defendant. The examples of ambiguous reference are left open for the listener, the ear, to decide. So what would be my recommendation then? Change the mode of delivery. Or provide the judge's summation in writing for the jury and the interpreter. Why not give, if it is written out, if it is a script that the judge is reading from, and it has been done before, why not give the jury and the defense and the witness, the defendant, why not give them all the written text? And they can follow along. Reduce the legal terminology. Remember that your audience is not trained to be able to accommodate legal terminology, and simplify the clause structure. It shouldn't be so complicated. What is register? This concept is based on what is field, tenor, and mode. Eric Steiner, University of Saarland, Germany, he's done a great deal of work in the theory of translation. He says this: register in particular becomes a key organizing concept linking context and lexicography, something to my knowledge which is not found anywhere else in modern linguistics. We're going to continue this discussion of what is register. We're going to look first of all, what is the language of silence? Okay, it's a little past 8. Let's take a break and Can you come back around 8:15, please?